A very good evening, everyone. I think we are live, so let's begin the practice hour for today. Hello, Akash. Please join in, all of you, so that we can start with the practice hour. Good evening, Shivani. Good evening, Akash. Good evening, Soumya. All right, so fine. So I think the screen is visible to you. I'm audible to you. You can hear me. Is everything okay? ठीक है, तो शुरू करते हैं फिर आज का practice hour. Right, without any further delay. So let's start. Okay. So under section 311 of Cr.P.C, a witness can be called on the motion of the prosecution, on the motion of the defense, on its own motion by court, all the above. What is the answer? What is the answer? Under section 311 of Cr.P.C. Good evening, Astha. Let's start with the question number 1. And we'll be doing only 20 questions today. So, tomorrow we can include 5 more questions. So yes, please, what is the answer? Under section 311 of Cr.P.C, a witness can be called on the motion of the prosecution, on the motion of the defense, on its own motion by court, all the above. All right. So only 2 people. People, do not forget to hit the like button. पहले ही कर दिया करो, सारा काम खत्म हो जाएगा. All right. Yes, please. What is the answer? Astha and Shivani. Where is Soumya? Where are others? Absolutely right. The correct answer is D. No, Soumya. It's D. Because, sometimes when the prosecution or the defense, so when you read section 311, you are right, you get that impression. But sometimes when the prosecution or the defense, they miss upon some witness. So now they cannot do it. So they request the court to call upon that witness. So that is also included over here. So it can be done on the motion of the prosecution, on the motion of the defense as well, right? So that is why all the above is the correct answer. Question number 2. Power to recall any witness or witnesses under section 300. So the question is mostly on section 311 and 320. And there would be 1 or 2 questions on 313. So we will finish this topic properly. Power to recall any witness under section 311 of Cr.P.C can be exercised even after the evidence of both the sides has been closed, after the evidence of the prosecution, before the evidence of defense is closed, before evidence of prosecution is closed, after the evidence of the prosecution is closed, if the witness is called on the motion of defense. What is the answer? Yes, please. What is the answer? Yeah, so that is why I told you the judicial precedents. That is why I told you the judicial precedents. That is a conceptual question, Soumya. I think I do discuss this in the class. So what I was trying to explain you is that sometimes when the prosecution or the defense miss upon a witness, so they can request the court to call the witness as a court witness. All right? This has been set through judicial precedents. So that is why when you mark in your preliminary, so you mark all the above and not just, only those witnesses which are particularly called by court. Is it clear now, everyone? Okay. Now let's talk about question number 2. Power to recall any witness under Section 311 of CRPC can be exercised. 2A, 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 2A. Absolutely right. The correct answer is 2A. Even after the evidence of both the sides has been closed. So it can be done here as well. Very good. Okay. Now question number 3. Under Section 313 of CRPC, the statement of the accused has to be recorded on oath, has to be recorded without oath, either on oath or without oath, depending on whether the case is a summon trial or warrant trial, either on oath or without oath as per the discretion of the court. Yes, please. Absolutely right. The correct answer is B. Has to be recorded without oath. This is something that is recorded without oath. All right. Question number 4. Recording of the statement of the accused. Recording of the statement of the accused can be dispensed with, may be dispensed with in a summon trial case where personal attendance of the accused has been dispensed with, may be dispensed with in a warrant trial case where the personal attendance of the accused has been dispensed with, may be dispensed with in a summon trial case generally. What is the answer? What is the answer? B. Fourth answer we are looking for, right? What is the answer for the fourth? Absolutely right. It is B. So when the attendance of the accused has been dispensed with, then in that particular case, recording of the statement of the accused may be dispensed with. It, it may be dispensed with. All right? Okay. Now, question number 5. Answers given by the accused to the question put to him while recording his statement under Section 313 of CRPC can be taken into consideration for judging the innocence of the accused, judging the guilt of the accused, for judging the innocence or guilt of the accused, neither for judging the innocence nor the guilt of the accused. Yes, please. What is the answer? Question number 5. बताइए जल्दी, quickly. Do we still have network issue today? Correct answer is C, for judging the innocence or guilt of the accused. Alright, this is the right answer. Okay, this is the right answer. Right? Let's move on to question number 6. Offences can be compounded under Section 320 of Cr.P.C by the legal guardian of a person under age of 18 years, a person who is an idiot, a person who is a lunatic, all the above. What was question 5? हाँ तो ये सिंपल है ना आकाश. 313 का जो स्टेटमेंट होता है वो विदाउट ओथ होता है, फर्स्ट थिंग. सेकेंड थिंग, जो 313 का जो स्टेटमेंट है, the purpose behind the statement is, which is being taken by the court is, so what happens is when the prosecution evidence has been done, so then, and the defense is about to present it, so in between that 313 ka statements come into picture. Why it is done by the court? It is done by the court to bring in the clarity with respect to if there is any gap which is left, and the story is not complete, and the court wants the story to get complete in order to do proper justice. So court जो है वो accused से पूछता है कि भाई what is your say in this? What do you want to say with respect to this particular issue which has been presented by the prosecution? All right, just to have a better understanding of whatever has been given by the prosecution. So the accused opinion, or opinion in the sense accused story, is also taken into consideration. So what is it going to do? And why it is taken without oath? It is taken without oath to remove that, fear from the mind of the accused, that if it gives any statement, so it can be used against him. All right. So now you can understand it has a broader purpose. So obviously, this kind of statement is going to, talk in respect to both judging the innocence or the guilt of the accused. Do you understand, everyone, what I am saying? So it's not just related to innocence, it's not just related to guilt. It helps the court to reach at proper decision. Now, the decision can be related to whether the innocence of the accused or the guilt of the accused. Is it clear, everyone? Now, D answer दिया है सबने. Absolutely right. Absolutely right. Very good, all of you. The correct answer is D. ठीक है, आगे चलिए. If the person who is competent to compound is dead, the compounding cannot be done, can be done by the legal representative of the deceased with the permission of the court, can be done by the legal representative of the deceased only with the permission of the court, both B and C. Without, बताइए, without the or only the, क्या है आंसर? What is the answer? Yes, please. What is the answer, people? It can be done without the permission of the court. Shivani, do you want to think on this answer? It can be done by the legal representative of the deceased. बताओ क्या है आंसर इसका? Where is Soumya? It can be done only with the permission of the court. Only with the permission, not without. Alright? So 7C, absolutely right. Very good. Under Section 321 of Cr.P.C, prosecution can be withdrawn in summon case without consent of the court. Prosecution can be withdrawn in a warrant case without consent of the court. In any type of case, but only with the consent of the court, both A and B. What is the answer? Yes, please. Okay. Who else? Absolutely right. The correct answer is it can be any type of cases, but only with the consent of the compounding of offence under Section 320 of Cr.P.C results in acquittal of the accused under all circumstances, acquittal of the accused only where the charge has already been framed, discharge of the accused where the charge has not yet been framed, either B or C. What is the answer? Yes, please. What is the answer? Asta, we have done this. What has happened to everyone? A is the answer. Acquittal of the accused under all circumstances. This is the answer. Please read section 321 again. Question number 10. Proceedings under section 258 of Cr.P.C can be stopped in a summon case instituted upon a complaint, in a summon case instituted otherwise than upon a complaint, in a warrant case instituted upon a complaint, in a warrant case instituted otherwise than upon a complaint. Yes, please. What is the answer? टेन का आंसर क्या है? Absolutely right. The correct answer is B. It's a summon case. It's direct from the section. It's a summon case instituted otherwise than upon a complaint. ठीक है? Now 11. The consent is not a valid consent under section 90. It's basically of IPC. Okay. The consent is not a valid consent under section 90 of IPC if given under a fear of injury or misconception of fact, if given by a person of unsound mind, if given by a child below 12 years of age, all the above. What is the answer? 11th का. 11th का आंसर क्या है? The consent is not a valid consent under section 90 if given under a fear of injury or misconception of fact, if given by a person of unsound mind, if given by a child below 12 years of age, all the above. Absolutely right. The correct answer is B, all the above. Okay. Consent given under compulsion arising out of threat of injury excuses the causing of death, excuses causing of any offense against state punishable with death, both A and B, neither A nor B. Yes, please. What is the answer? बताइए. 12th का answer quickly. Quickly, people. It's very easy. Correct answer is okay. Very good. The correct answer is C. The maxim de minimis non-curate lex means अब ये सबको पता है. बताइए. Law would not take action on small and trifling matters. Law does not ignore any act which causes the slightest harm. Law would not take action in serious matters. All the above. क्या है? बताओ 13 का क्या है? जल्दी. Is the question not reaching to you, or is a lot of time there? Absolutely right. The correct answer is the law would not take action on small and trifling matters. कहाँ पे है ये? ये प्रिंसिपल कौन से सेक्शन में देखने को मिलता है हमें? Which section of IPC talks about it? Class. Which section of IPC talks about it? Very good. Section 95. Okay? Section 95 of IPC. Fine. Question number 14. The right of private defense is based on the natural instinct of self-preservation, self-respect, self-sufficiency, self-reliance. What is it? The right of private defense is based on the natural instinct of self-preservation, self-respect, self-sufficiency, self-reliance. What is it? 14 का answer is others. Absolutely right. Correct answer is self-preservation. Very good. The right of private defense is unrestricted, subject to restriction contained in section 99 of IPC, subject to restrictions contained in chapter 4 of IPC, subject to restrictions contained in any other provisions of IPC. Yes, please. What is the answer? What is the answer? This is easy. Everyone knows. It is subject to restriction contained in section 99 of IPC. Okay? Okay? Very good. The right of private defense is available with respect to harm to body, harm to movable property, harm to immovable property, all the above. This is again easy, but then all these things clear your concepts, and that is how you can write in your mains also. And you can definitely get a preliminary question like this. So yes, please, what is the answer? The answer is absolutely right. All the above. Very good. So harm to body, harm to movable property, harm to immovable property, suddenly. Okay? For writing, which of the following is correct? For writing, which of the following is correct? Actual force or violence must be used. Mere show of force is sufficient. Mere possession of deadly weapon is sufficient. All the above. What is the correct answer? Yes, please. What is the correct answer? Others, do you have a different answer from them? Anyone who has a different answer? A is the right answer. Actual force or violence must be used. Alright, actual force or violence must be used. That is the right answer. The presumption of continuance of life is contained in which section? 106, 107, 108, 109. Quickly. The presumption of continuance of life is contained in 106, 7, 8, 9. Quickly. No? You know this. We have done this. Section 107 of your Evidence Act. Section 107 of the Evidence Act. Okay. Section 108 of Evidence Act relates to what? if presumption of life is under section 107, so section 108 of Evidence Act relates to? बताइए. Question number 19, people. And we have one more question to go. So presumption of what? Presumption of death. Absolutely right. This is the right answer. Presumption of death. And the last question for today is, for presumption under section 107 of Evidence Act, the person is to be shown to be alive. This you know. And this question should not get wrong at the time of the exam. So, for presumption under section 107 of Evidence Act, the person is to be shown to be alive within 7 years, within 12 years, within 3 years, within 30 years. Yes, please. What is the answer? Alive की बात कर रहे हैं. Under 107. Alive. The correct answer is within 30 years. He should be shown to be, when we talk of presumption of death, then we talk of 7 years. He should not have been heard of 7 years. But when we are talking about presumption of life, then it has to be shown that the person was alive within 30 years. Alright? The person was alive within 30 years. So fine, I'm done for today. I'll be meeting you again tomorrow at the same time at 4 p.m. and I'll be adding some questions on Rajasthan also. Today, sorry, I'm not able to do it, but I'll be including it tomorrow. Alright? So take care, all of you. Thank you so much for joining in, and we'll continue the practice hour again tomorrow. Thank you, all of you.